Okay, it's 9 o'clock.
Good evening, and welcome to the very first webinar hosted by Lawmato in 2022. Lawmato is a one-of-a-kind app for legal consultations. It is truly a very easy and simple app for clients to find the right lawyers and to get a lawyer to respond and quickly. For more information about Lawmato, you can visit www.lawmato.com. And this webinar is available via Zoom and live stream with YouTube. Tonight, our speaker is Josh Becker. Josh is an international trade attorney at the law firm of Givens and Johnston, PLLC. It's a boutique international trade law firm in Houston, Texas. And Josh's practice focuses exclusively on advising clients in import and export matters. Of course, that includes cross-border trading activities. With that, I will turn the mic to Josh and have Josh give us maybe an update on the trade war, or we call that tariff increase by former President Trump. Josh?
Sure. Well, thank you, Tom. I really appreciate it. As Tom mentioned, I'm a international trade attorney with Givens and Johnston. I've been kind of, I guess you could say, on the ground floor of this matter for the past, I guess while we're nearing 5 years into the nonstop activity that are, these ongoing tariffs between the U.S. and China. So if you'd like, I can go ahead and start with just a brief, overview. Really the main issues today that are impacting importers of goods from China are, first and foremost, the Section 301 duties. These are the so-called Trump tariffs. The Section 232 duties. These are the duties on the steel and aluminum. And more recently, the recent bill signed into effect by the Biden administration that targets forced labor in China. So those are the three, kind of main import issues today. If for those who are unaware, the Section 301 duties, those are definitely covering the most goods and definitely the most detailed. So I'm obviously happy to talk about those ad nauseum if you guys wish. So, Tom, I don't know where you wanted me to start, but I'm happy to talk about anything.
Thank you, Josh. Let us know if you have any update on those lawsuits that when the Trump duty came out and the industries filed, I understand was thousands of lawsuits.
So that's correct. So there's been a lot of litigation on pretty much any of these duties. So the first ones, the ones that kind of have already kind of started going through the court system and are already progressing, those cover the 232 duties. And so those are global tariffs. That's global tariffs on steel and aluminum imports. Eventually that expanded to derivative products as well. Those are more or less, importer specific lawsuits, but also policy lawsuits, suits against those tariffs. The big one, however, is a suit filed by thousands upon thousands of importers challenging the Section 301 duties under the grounds that they were not properly administered and not properly or legally obtained to begin with. So at this time, we've got something like 7,000 plaintiffs basically challenging these duties. As luck would have it, we have oral argument in front of the Court of International Trade coming up shortly, soon after this webinar actually, so I'll have much better updates very soon. But that is, yeah, that's where we stand right now.
You mentioned 7,000 lawsuits.
Mhm.
Are those suits filed in one court or in various different district courts?
That's correct. It's just in one court. So the best venue and the best jurisdiction for trade issues is the Court of International Trade up in New York City. Basically, they have direct jurisdiction to hear cases arising out of trade matters and trade policies, with few exceptions. For the most part, that's what they focus on. So all of these importers have been able to file with them, yes.
Okay, are they filing suits with regard to the list 1 through list 4, or just the 1 or 2 or 3 or 4?
Sure. So the main challenge is on list 3 and list 4. So the argument behind the scenes goes kind of like this. So initially, under the actual Section 301 of the U.S. Trade Act, the president has the authority to levy certain types of duties on certain types of goods without going through the legislative process. However, what the president does need to do is initiate an investigation. The U.S. Trade Representative must take part in it, and the public gets an opportunity to comment and respond on the various issues raised by this investigation. Ultimately, the investigation found that there were faults in the U.S. and China trade system. Specifically, what was being investigated was whether or not Chinese companies are forcing the Chinese government is forcing U.S. importers to hand over intellectual property in order to do business in China. As a result of that investigation, the U.S. Trade Representative put out 2 lists of goods. List 1, which covered $34 billion worth of trade, and that's mostly kind of some tech products, some raw materials, not really, things that affect everyday people. And list 2, which was predominantly oil field equipment and other machinery. And that was as a direct result of this investigation. Later, and seemingly arbitrarily out of nowhere, list 3 suddenly came up. List 3 covers $200 billion a year worth of goods. And even more randomly, President Trump one day just tweeted out that there would be more goods covered, an additional $300 billion worth of goods, and that is list 4. So pretty much the entirety of this lawsuit revolves around how list 3 and list 4 were created, the fact that they came after that investigation had concluded, and that they appear to be completely arbitrary. And that is the grounds behind that lawsuit. Yeah.
Okay.
Yeah.
And all those tariffs still in place. The Biden administration has not canceled any of those, right? Or
they have not. No, they have not canceled any of these duties at all. The Biden administration has allowed some exclusions that used to exist. They've allowed them to come back. There are.
Wait. Tell us about exclusion, just in case the audience is not familiar with this process.
Sure, of course. So as part of the kind of public comment and response period that these duties were born out of, one issue that the public raised was, what if I cannot get my goods from anywhere except for China? And so part of that, the government stated that, okay, we understand that that is a possibility under certain circumstances. So they opened the possibility to get an exclusion from goods. There was, for each list individually, an opportunity to seek an exclusion based on a number of pretty much ever-changing criteria. And those who were able to prove that you could actually get that you couldn't get these products outside of China, or that there were other circumstances as to why these exclusions should be granted, they were able to get an exclusion for the goods. Temporary exclusion, I should note. It was not forever. After that, eventually another system kind of came in that allowed for people to get an extension on those exclusions. Ultimately, that it worked out. People did get some extensions, but the government said it would be for a certain period of time. And then it really just ended up being until December 31st, 2020, when when President Trump left office. So, and that's where we stand. All of those exclusions had ended back then, and recently the Biden administration started allowing people to apply to reopen those.
Well, that sounds like a positive news for the importers.
It is. It is.
Well, then tell us more about what opportunities are there. I mean, I understand Biden did not give extension back to every type of products, only certain limited numbers, right?
That's correct. Yeah, that's right.
What are they? Maybe the listeners may
compare. Sure. Yeah, no, I mean, absolutely. We'd be more than happy to help folks potentially benefit from this. Yeah, so unfortunately, the Biden administration opened a very, very slim, narrow opportunity for exclusion. So the criteria is kind of threefold. The criteria number one is that the goods had to have been excluded before. Criteria number two is that the exclusion had been extended. And then number three was, once again, another survey on all of your business information and world trade data to confirm that you're still eligible for that exclusion. So that opportunity is currently under review by the U.S. Trade Representative and the Biden administration. There is one other potential opportunity coming down the line, and this one's a big one, and it's good news. There was a bill that recently passed the Senate. I want to say pretty strongly passed the Senate. I don't remember the exact numbers on it. And it's on its way to the House right now. And the purpose of this bill, amongst many other things, is to reopen exclusions pretty much across the board. The main focus of this bill is U.S. technology industry and kind of helping them offset some of the costs from this trade war. But in the bill, it does bring up the opportunity for all importers to seek exclusion again, create unified criteria, unified baselines for granting these exclusions. So that's hopefully coming down the line. Like I mentioned, this has passed the Senate. It is on the House floor, so we do not know exactly what that final bill will look like, but it's looking good. It's looking up.
Okay, so this better, more dynamic bill is still pending. The Biden initiative is being reviewed by the U.S. Trade Representatives, and hopefully that limited relief will come out soon.
Yeah, unfortunately, I can't give you an exact date on that. That's the hope. Soon is the hope. The good news, I guess, for everybody out there listening who's hoping that they could get one of these exclusions, is they will be retroactive back to December of 2020. So
does that mean they get a refund from the
That's correct.
Customs?
Yeah. Yes. So you will have to apply for that yourself. It will not be automatic. You will have to record, depending on the status of the goods. There are two different ways that we can, that you can get that. But yes, you will be able to apply for retroactive treatment and hopefully get, your 2021 duties back, which will be a huge relief for importers for sure.
Oh yeah, that'd be great news. And I assume if the Senate bill becomes effective, then that's even better. Those will be retroactive as well.
I'm not 100% sure. It's there was some discussion kind of in and around there, so I'm not really 100% sure exactly what would be and what would not be. So
okay.
I'll chalk that up as a let's wait and see.
I was trying to get some hopes up for the
Listen, I would love to do that. The past few years for me, I feel like I've been the bringer of bad news. Every time I email a client, they know it's not anything happy. It's starting to turn around though, and I finally get to do some good news for people, which is nice for a change.
Okay, well, at least that's some good news, potential good news coming your
Yes,
way. Yeah.
absolutely.
Uh, you mentioned 301, and you mentioned 232. I don't think you have elaborated on the 232 yet. Tell us
Sure.
more.
Yeah. Okay. Certainly. So Section 232 it applies globally. This is not just a China-specific trade initiative. What Section 232 does is it allows the president also to bring on new tariffs with a national security focus. So once again, there is an investigation and a reporting requirement. In this case, that the investigator was the Department of Defense, actually. So this was, when Secretary Mattis was still the head of the Department of Defense. The investigation went through him. And the purpose of this investigation was basically add tariffs on foreign imports of steel and aluminum under the premises that steel and aluminum are crucial to national security in the United States and that we must protect the domestic industries. Once again, there is an exclusion process, and it is an ongoing and ever-present exclusion process. So ever since the 232 duties have been in effect, there has been an exclusion process. It is incredibly detailed, incredibly product specific. And unlike Section 301, where if a good is excluded, any importer of the product gets the benefit of that, under Section 232, the only person who could get the benefit is the importer specifically. So, but there are some lawsuits also on 232, but it's very different in scope.
Thank you. Just for those who might just join us, we are having a 1-hour discussion today with Josh Becker. Is an international trade lawyer. He's based in Houston. The firm's name is Givens & Johnston. We are talking about the trade duty status right now because there are a significant number of businesses that are focusing on this industry, and they have had ups and downs, and this, especially in this unpredictable situation, and we're trying to shed some light on this uncertainty. Josh is kind enough to give us this update. Looks like the Biden administration is going to continue the Trump duties and even more. Now let's focus on this. The Biden forced labor issue. What's up about that?
Sure. So this is a big one. And by the way, I just want to really quickly note, I see that we've got a bunch of questions and I will gladly answer them. Just give me one moment and I'll gladly talk about the forced labor issue here. So the forced labor issue it's a big one, and a lot of people need to start getting ready because we've got 180 days basically to get everybody in compliance here. So for some background, as I'm sure a lot of folks listening to this probably know, the United States government and a lot of other world governments allege that there are rampant forced labor violations going on in China, specifically in the Xinjiang region, targeting certain ethnic minority groups. So there is a part of the U.S. trade regime. The code section is 19 U.S.C. 1307. It's not very commonly used to make any form of trade policy. However, it has started picking up as of late, not just in China, but across the world. And just before Christmas, on December 23rd, President Biden signed into effect a law that basically said that there will be a legal presumption that any goods manufactured, made, produced in Xinjiang, that those goods are made with forced labor, and therefore they are not allowed to be imported into the United States. Furthermore, and kind of complicating the issue more, is the fact that the bill explicitly lists that the issue is not just Xinjiang, but a lot of the companies over there are moving people outside of the region and keeping up the same kinds of acts. So realistically speaking, the scope of this bill is basically, if you want to take a very aggressive view on it, it is claiming that there's a legal presumption that most goods made in China are made with forced labor and therefore prohibited. So there will be guidance from customs coming down in the next 6 months as to what exactly they mean by that, what exactly they will be targeting, how importers can comply with that, and what you should be doing as an importer to comply as well, and what the government will be doing to enforce. So yeah, it's a large bill in terms of scope, for sure.
So just to be clear, you say it's a Xinjiang, the northwestern part of or the west part of China, not Shenzhen, not the southeast.
Yes, and I do
Yeah,
I do apologize if my pronunciation is a little bit off for the.
No, you were there. I just want to make clear, and also you saying the forced labor is not just limited to the practices. Is not limited to Xinjiang.
That's correct.
If manufacturers in other parts of China that involve forced labor, those products will be subject to this ban as well?
That's correct. Yeah. So I was, the exact language in that bill, actually, I've pulled it up in front of me, is that it is prohibiting the importation of goods made by any entity that works with the Xinjiang government to recruit, transport, transfer, harbor, or receive forced labor of Uyghurs, Kazakhs, Kyrgyzstanis, or members of any other persecuted group. So, as an attorney, whenever I see something like any other persecuted group, that's not defined, right? That leaves it open to the government to tell me what that means. And that could mean a lot of things. And when you're talking about moving people, moving facilities, moving, transporting, services around, this creates, a China-wide problem where now, instead of checking geographically, do I have a supply chain in this region? Now it's kind of shifting the burden to say, okay, does my supply chain have this issue anywhere else? Can I trace things back to this region? And not just this region, but companies that operate in that region. And that's really a very large and very difficult burden to overcome. So that's right.
What if small companies just ignore this regulation? Just say, hey, I'm too small, and I'm honestly believing that my products are not the product of forced labor. Therefore, I do not want to spend the money to try to be compliant.
Sure.
What's the consequence of that?
Well, you will be hit with, at a minimum, a denial of entry of your goods if customs, alleges that this is happening with your product. So, and that's at a minimum, and then you'll also be facing a penalty. The way the penalty is calculated kind of depends on the level of culpability that customs believes is present. It can be up to and including the cost, the fair market value in the United States of the goods. You could also end up getting hit with violations of your import bond, which are very, very painful for importers. But we're starting at a minimum of the complete, detention and destruction of your goods, of things that you're importing. So that would be the bare bones minimum.
So that's assuming if the customs catches you or suspects that your product might be. Right?
There you go. Yeah, that's a big one. If customs just suspects this issue, their first move will be to detain your goods. That's the first thing they're going to do. And they will send you a notice saying that they have detained these goods. If you're lucky, the first thing that they will actually ask you about, they'll actually just send you a questionnaire and be like, we have noticed this shipment. We suspect this is going on. Please provide us all of this information in the next 30 days. And they're going to be asking for things like pay stubs of employees. They're going to be asking for timesheets. employee addresses to make sure that they're not living at the factory. You know, they're going to be asking for passport numbers. They're going to be asking for transportation records to make sure that, you know, everything along the way is not covered by this. It's going to be a lot of evidence that you're going to have to provide in order to try and get your goods
I'm
released.
surprised this draconian regulation is not being talked much in the industry.
Yeah, well, I mean, listen, they're part of the reason is because it is so scary. The realist in me, and I think in a lot of other people, is saying that we really should wait to really talk about, you know, the nuance of this, you know, in 180 days when customs by statute is going to be ordered to put out their criteria. So at this point, you know, part of it is speculation, but, you know, this is what the statute says. And I want to kind of stress that I'm not, you know, trying to overinflate this. This is part of a pattern that we've seen with customs lately. You know, the amount of withhold release orders, which is what it's called when customs bans the importation of a single product, has skyrocketed as of late. You know, we actually had issues where during the peak of the pandemic, you know, early 2020, pretty much the entire world's supply of latex gloves was put under a withhold release order. And that's a huge reason why you were not able to find latex gloves in the United States. And nobody mentioned the reason why. It was because customs had actually alleged that all of these gloves that were manufactured in Malaysia were made with forced labor. And, you know, obviously customs can't have their feet on the ground, especially during the pandemic. So this isn't their own research. This is people and NGOs and you know, folks over in Malaysia reporting this to customs. Customs begins an investigation, and, you know, once they put that one product on there, the biggest supplier got caught up in it, and, you know, they went through this rabbit hole with customs, and, you know, luckily they were able to get their product off the list. So,
oh, good. Well, here we go. We thought
I should mention that large cost to them. Yes.
Okay. Well, we thought it was because the port congestion or the
well, there's definitely some of that going on as well. You know, there's definitely a lot of that. But yeah, no, that was in early 2020. I helped some individual importers of those goods, not the main company themselves, you know, that were importing that at the time. And, you know, we had to help them get their goods released, you know, talking about entire shipping containers of latex gloves coming in the middle of a pandemic. Hospitals have them on order and couldn't get their literal hands.
So on top of the logistics nightmare, you have the customs detention on top of that. So they compounded. So what is the correct measure to take if a importer that imports business products from China, and regardless whether they're, you know, cotton or tomato sauce, that's the two items I can think of, or maybe
those are two big withhold release orders. Yes.
Sometimes I guess jujube, the dates from that part, and I consume quite a bit of that myself. Regardless whether they purchase anything direct from Xinjiang, what should a importer do now?
Sure. I think at this point, the most prudent thing that importers need to do is really starting to vet their supply chains as well as possible. And I don't mean, you know, just the guy you're buying from. I don't mean your first tier, you know, suppliers only. I mean everybody. It's time to start putting in place programs, routine compliance programs to ensure that you're remaining compliant with this. You know, if customs suddenly detains your goods, you're put in a position where you have to defend yourself. But if you're starting to do this proactively, A, you're removing the possibility that any of this is in your supply chain, and B, you are already actively building your evidence, you're actively building your, your database and the things that you can provide to customers to show, hey, this is not my problem. This is not in my supply chain. Please release my goods. So if you're in a position where you could put programs in place, documentation, record keeping, vetting, now would be a great time to start.
Okay. And you're saying 6 months from 180 days?
Yeah. So assuming we don't get any extensions on that, yes, the bill said that it will take effect 180 days after it passed, and it was signed into law December 23rd of 2021.
Okay, that's good to know. Collect evidence, then or prepare information.
Mm-hmm.
What's presentable at the customers if they are detaining your products and you say, hey, here's my summary.
Sure.
Does that carry any weight if the importer's own summary or information pack?
I guess let me, kind of answer that in two ways. So, that will mean nothing on the ground level. I should mention that, right? Like, if, first off, your personal opportunity to stop customs from seizing your goods at the actual ground port level is pretty much, it's very small, right? We're talking about once it makes it to the administrative level, once it makes it to the, the fines, penalties, forfeitures officer at the port, once it makes it to, the seizure officers who actually handle these transactions. One thing that I would caution is customs so far has shown that they're not really willing to take an importer's word on it. There was a very big customs decision recently targeting a importer of clothing, one of the large label importers of clothing who will remain temporarily unmentioned. They had a whole lot of their goods seized immediately upon entry. Customs had alleged that the cotton in those shirts was from Xinjiang. They requested everything in the world that you could think of. They wanted all of the information on the product, the entire trip over to the United States, the workers, everything. Ultimately, the company thought they had submitted enough, and Customs still said no. And part of the reason was because, frankly, they probably did not submit enough. They had not fully vetted their entire chain, and they only submitted what they knew at the time. And so that the reason I don't want to really talk about it much is because it's still an ongoing issue, and they're not thrilled with the outcome they got initially with Customs. That's going to keep going. But
so even if it's a positive outcome, you still got delayed. What? How long is the standard?
That was, boy,
delay.
Those goods have been sitting on the dock for at least a year now. So those goods are useless, right? It's clothing we're talking about. It's out of season. It's out of fashion.
That's tragic. Now with that, if a company that comes to you say, hey, Mr. Lawyer, help me because my self-serving affidavit is not helpful, you wouldn't be able to create any more information than what they present to you. Do you, and I'm just guessing, do you have any suggestion whether a neutral, trustworthy, say US operated certifiers in China that might help these guys so the customers will believe them more? Who puts a stamp on this certificate? Or
Sure, yeah. So
what's the solution here?
There's a couple different solutions. Yeah. So the first thing that I would do is, if somebody came to me before they got their goods seized, I would help them understand what they need to put together initially in order to start building that. That would be number one. I would really help them start building a program. If somebody came to me when the goods, had already been detained, at that point, I'm trying to gather as much evidence as I can. I'm trying to find, like you mentioned, reputable people to go down there and, make a verification, take pictures, document it, geocache that data, as much that we could do to verify, the validity of this. We would try and do that. We would submit a petition to the government, and we would try and frame, obviously, the information in the best light possible, all things considered. There are some concerns, however, when it comes to these accreditation agencies. One of the biggest, most glaring issue with forced labor is the Chinese government and the Chinese companies, to that extent, they don't acknowledge that this is happening. So if a third-party certifier is going down to check on this, they are putting themselves at a minimum of business risk of saying something that goes against the narrative over there. So that's a difficult concern for sure.
I see. I literally, it's challenged at many levels, because
Yes.
you are presumed guilty, then
Mhm.
your evidence is presumed to be
Not good enough.
invalid, right?
Right. Yeah.
And
So this is a thing that, in the legal field, we call this presumption. It's called a rebuttable presumption. The goods have a presumption, but you, the importer, are allowed to rebut it. I've been jokingly calling it an rebuttable presumption.
Mhm.
I don't know.
Yeah.
I'm not sure how you do that. I think one of the things that I suspect is they're going to have to be a little bit more lax. I suspect there might be some kind of maybe de minimis rule, or something, or maybe if it's a certain amount of degrees removed. I don't know exactly how that's going to work, but I suspect there will be more.
Okay. You talk about the irrebuttable assumption here, and let's pause for now, because I'm thinking, if every single shipment coming out of China has to be inspected, suspected, detained, or denied, then on top of the logistics nightmare, how is Walmart going to be able to maintain its shop?
Well, that's difficult. Yeah. So I don't think, I don't want to be super alarmist here and super scary. I don't think that everything is going to be targeted at first, at least. I think you're going to see enforcement start at the most suspect groups, even before China, the apparel industry has always been suspect. So, it's most likely that customs will focus on apparel. We mentioned withhold release orders earlier. There are active withhold release orders currently on cotton and tomato products. I suspect that this is where customs will start their enforcement, but where they go from there, that time will tell. Yeah.
Yeah. Think of the massive scale. It's almost unimaginable that the government would be able to police this.
Yeah. Oh, absolutely. Absolutely. That is yet another concern. And, all I can say right now is I'm really glad that I do not work as a customs officer in the Port of Los Angeles, because that's where all of this is going to be going on. So it's going to be rough. It's again, I keep mentioning, I really hope that we get some more clarity in the 180 days. And I suspect we will, but I'm really hopeful for better news than what is written in front of us today.
Yeah. Now let's answer some questions.
Sure.
Before you get stale. You want to go with the list?
Yeah, let's see. I see Lorianne has sent quite a few, so let's go help her out if that's all right. So It looks like the first question that we got is, where would a business find the lists to determine if they must comply and are an issue to manage? Okay, so I assume this is with regards to to the section 301 lists. So list 1, list 2, list 3, and list 4 are all found on the U.S. Trade Representative's website. But more importantly, your customs broker will know the goods immediately, because in the harmonized tariff schedule, they are marked accordingly. So every single list has a corresponding tariff number. So when a good product from China enters the United States, let's say, line pipe, the line pipe will have its own HTS code, and then that HTS code will also have a, then the corresponding list will have an HTS code as well.
Okay, you want to go through the same line of questions there, or?
Yeah, sure. Here's here's a longer question. So let me just skip over that just briefly. Let me go through a couple of these quick questions. What is the bill number if we want to watch its progress? So I think that's probably the bill number for the upcoming exclusions process. It's called the United States Innovation and Competition Act, or USICA. So that's how you can follow along with them if you'd like. Average range of how long it takes goods to get out of customs detention. My joking answer is it depends on how good your lawyer is. But no, in all seriousness, the ports are slammed. So the real answer is it depends on which port you're at. If you've got something at, up in Minot, it's not going to take as long as something in LA or in Houston. Yeah. So another one, our products were excluded from the Section 301 duties for about a year. During that period, we were exempt from paying 25% tariffs, and we're told that the tariff we previously paid would be refunded by the government. Yes, that is correct. That's how it works. If you had an exclusion for a year, your goods were entering during that year without the duties, and moreover, you were entitled to a refund for duties that you had paid. We had previously, our customs agent filed the refund claim for us, and you received one check from the government, but heard nothing else. What would you know about the refund process? Should we pursue this further? Okay, the refund process. That depends entirely on what kind of document was filed with the government. So there's two main ways of doing this. When goods enter the United States, you obviously receive your goods. That's what happens. Most importers have what's called immediate importation privileges. So, the good comes into the port, it's put on a truck, you get your product. What's actually happening behind the scenes is there are just a very large amount of paperwork going on, and the process is called liquidation. So goods can liquidate in a couple of different ways. The first way is customs actually sits there reviewing your goods, and when they're done, they say done, and they liquidate it. And the other method is just a statutory time period, which I don't know how they came up with this number, is 314 days. So when you enter your goods, if they have liquidated, you would file a protest in order to get your refund. If they have not liquidated, you would file what's called a post-summary correction in order to get your refund. The post-summary corrections are generally much quicker because basically what a post-summary correction is it's a new entry summary. So they're reviewed very quickly. If they are not reviewed by the time that the goods liquidate, then they're kind of, I don't want to say denied, but they're just kind of worthless. And then the importer gets the opportunity to protest that. In the event of a protest, customs could sit on that for a very long time. The statute says that they should review it within 2 years, but unfortunately it says should review in 2 years, not must review in 2 years. So they could sit on it for a while. My answer to you would be find out from your broker if they filed a PSC or a protest. And if they filed a protest, have them get in contact with the person at customs reviewing that protest. You know, assuming they filed the protest online, which you can do these days, it will tell you which team at customs is reviewing your protest, and you can find out a little bit more. Should you consider pursuing this further? Yes, absolutely. You should absolutely, you are entitled to relief, and you should absolutely get that relief. I guess a little silver lining that I could say to you, you did mention that you received one check, which means customs did approve it. That the good news is probably the rest will be approved as well. And in which case you're sitting on some interest, which is nice. So there's a little interest the longer you wait.
Okay, Josh,
Yes.
I saw the question, and we have to be very careful not to show any bias. The customer clearing agent handling this refund, and maybe that's the correct approach. But I would like for you to, as a fellow professional dealing with the trade agencies. But I'm asking this because often business people will ask their CPAs to do legal work and put the CPAs in a very difficult situation.
Yes.
Do you see any customers, meaning business people, overuse the broker, the clearing agent?
Overuse the brokers.
Sort of lead them to do things that they are not supposed to do. I'm not saying in this situation that's the case, just so we have to be very careful in general.
Okay, this is a difficult question for a couple different reasons. Listen, your customs broker is your friend. Don't get me wrong. Your customs broker knows your products probably better than other people do. Your customs broker is excellent at getting goods in and out. They've got a wonderful relationship with customs that helps facilitate this. What your customs broker usually isn't is they're not your advocate. Because frankly, that's just kind of the nature of their business. Their business with customs is making sure your goods go through, so they don't really want to poke customs too much, right? Should a customs broker be filing your protests? Maybe not. I would say that in my experience, I've seen some good protests filed by customs brokers, but their training, their skills really are in the entering of products. I would say that, seeking legal help is probably the best thing to do for a protest. For post-summary correction, your broker can generally handle that. If you really want to cross your T's, dot your I's, my recommendation oftentimes, especially if you have trade counsel, is have your trade counsel prepare a cover letter for that post-summary correction and have your broker file it. And that's something I've done on numerous occasions for my clients. The post-summary correction is much easier handled by your broker than by an attorney, but it does not hurt to have that cover letter fully explaining why you're entitled to that post-summary correction, why you're changing the entry, and why you're entitled to what you're changing it to.
Thank you. I know that was a difficult question.
Yeah, it's,
you and the customer agents, you're working as a team.
Yes, absolutely.
Right. So
absolutely.
There's a line where the level division happens.
Yes.
And I want to point this out because not that business people are intentionally circumventing, but it's because they know the broker so well, they don't know you. they don't even know where you are.
Yes.
So that's why Lawmeto comes in. If you
Yes.
feel your broker has tried its best and still has not achieved the desired results, outcome is not satisfactory to you, you do want to speak to a lawyer. Now you know Josh Becker is on Lawmeto. Just download the app Lawmeto and you go search for import export. Bam, you see a list of lawyers and Josh is among the excellent lawyers there. So that's part of that why Lawmeto was created. It's truly very convenient for people. You mentioned, let's move. We still have about 10 minutes, and we welcome additional questions. But I still have some questions here. The 7,000 people who have business which have sued I guess sued the government, right?
So
to ban the regulation from being enforced. If they win, what happens? If they win, do the importers automatically get to become part of the class, or do they have to file their own to?
Sure. Okay. This is. I'm going to try to answer that without getting too much into the weeds about the specifics on the law, because I know, as lawyers, we love to talk about that. That's why we became lawyers, but not everybody wants to hear that. Okay, so it's good that you mentioned class, right? So normally, the way that large scale issues like this are litigated through the courts is through a class action lawsuit. Someone has a defective car, everybody with that car can sue the government under one case, right? Or sorry, sue the car manufacturer under one case, right? That's not how it works in the Court of International Trade. The way it works at the Court of International Trade is if somebody files a case in front of you, before you, and you have the same law or facts as that person does, what you can do is you can file a suit and ask the court not to look at your suit until that first one, case A, we'll call it, is done, right? So that's the reason why we say also that 7,000 people have sued, as opposed to there is one lawsuit with 7,000 people in it, because the effect of this rule is, in essence, there are 7,000 cases. In reality, there is one, right? It's just that first one. And that first one will be litigated out, and everybody who filed, for the most part, will receive the same treatment. There's a few, small nuance to go with that. Now, what happens if they win? Well, the first thing that would happen is list 3 and list 4 would most likely go away, right? Because the way that you win is if the court finds that the plaintiff's argument that list 3 and list 4 were born out of improper, administrative activities, that would go away. And that would be fantastic for everybody. Wait.
If those list 3, list 4 go away, my importer clients have already paid the 25% or 10% or however many percent in the last however many years. Do they get refund?
Yeah, that's the goal. Yes. So this is a sticky wicket in a couple different ways. So, early on in this litigation, that was the most important question to everybody, right? If we win, do we get our money back? Otherwise, what's the point? So the case law says yes, you're entitled to a refund. So what plaintiffs' attorneys got together and decided to do was we asked the government to stipulate to the availability of refunds. Basically, have them say that they will not challenge our ability to have a refund. Unsurprisingly, the government refused to do that. So instead, the plaintiffs filed an injunction against the government saying that if refunds are not available, we will be irreparably harmed, sorry. And therefore, customs must be enjoined from liquidating entries going forward, because otherwise we wouldn't be able to get our refunds. The court actually upheld that. They granted that injunction, which was fantastic. And over the course of a few months, we kind of tried to work out a way for that injunction to actually work administratively. And ultimately, customs gave up and said, we can't make that work. We agree to your stipulation. We will stipulate that refunds will be available. So yes, if this case goes through fully, if the courts side with the importers, you will get a refund.
Well, then if I'm not part of the 7,000 plaintiffs yet, do I get to file anytime? Should I file anytime?
You can file at any time, yes. So there is a legitimate question about how payment would work, right? Who is entitled to what and how as a result of a victory, right? My easiest answer to that is file a lawsuit yourself. You will be a named plaintiff. The government will know exactly who you are, what you're doing, and you're going to get paid first if this works. There are some other really small things kind of here and there that I could discuss with a client directly about how filing now would affect them versus filing later. But yeah, absolutely, you still have an opportunity to join the litigation, and I would recommend anybody do so. Absolutely.
It's not as expensive because
no. There's a pretty much at this point standardized fee. Once one attorney's fee leaks out, everybody has to follow it. So it's not very expensive at all.
Okay. So if you are in the business of importing at least from China under the 301 Trump rate, you should file that symbolic lawsuit, I would say, just for the future possibility of receiving the refund of the duties you have paid.
That's right.
Whether the payment will be made remains questionable because it's difficult to do, but it's for another day, I guess. We are about to run out of our 1 hour time, but you're welcome to stay on if we have more questions. Let's see. You want to check the questions here?
Yeah, sure. So let's see. There's a question about people starting e-commerce businesses and what are the best steps to prepare before starting the business. All right. There is actually a very interesting thing that can be done to help you. There's a provision in the import laws of the United States that basically tells you that if you are importing less than a certain amount per day, then you don't need to file a customs declaration, and frankly, there's no duties attached to it. The real benefit of this is, the normal benefit of this is you're coming home from abroad and you've got a couple gifts. You don't need to pay duties on that. There are some other implications though about it. You could get clever and structure your e-commerce business in particular in a way to where, maybe you, the e-commerce company, are not importing goods from China, but every single one of your customers individually is. And therefore you don't pay duties on that. So my answer to you would be talk to an attorney. Not just a trade attorney, somebody who helps you structure your business as well, and like a business attorney, and absolutely review those lists, review anti-dumping cases, review all of that as best you can before you get started. That would be my recommendation on that. There's a lot out there, and frankly, Tom used a good word earlier, draconian. Not only are the tariffs bad, the penalties are worse. They are absolutely completely draconian. So it is best to do your due diligence and find as many little, potential issues as early as you can.
Okay, well, I still would like, if you don't mind, to ask let's cover some export questions.
Okay, yeah,
we've
certainly.
been focusing on import the whole evening. Yeah, just what export concerns should the U.S. companies doing business in China or elsewhere be aware of? I mean,
okay, yeah. So generally,
I know time is short. I just give us some, takeaway.
Sure. So generally across the board, no matter where you're exporting your goods to, be aware of the sanctions regimes, be aware of what's called the entity list and the denied persons list. Do screening, know your customer. That's the most important thing that you need to do. Have something in place that helps you screen who is buying your product or anything like that. Just check those lists, check the sanctions programs. That's the best simple answer that I can give you. China specific tech companies need to absolutely watch out. There are just an ever-changing amount of just the export regime to China changes all the time with regards to tech. So you got to look out for what we call deemed exports, which is when you're not physically sending something out. You're exporting to a country by having a foreign national see that information because you've technically exported to that country through the foreign national. You need to look out for the classification of your goods, make sure that that it's okay to send them over there and all of that. Yeah.
Now you are asking people to do the KYC, to do the diligence.
Mm-hmm.
Would it be better to say, hey, I don't know. I didn't know this when I was signing the contract, they were on a entity list or they're on a sanction list. Is not knowing, ignorance, a defense in this situation?
Nope. Sorry. No. Ignorance is not a defense in this situation. In fact, if you told the government that, your penalty just went up. So yeah, I would not. No.
Well, one more time, I'm saying to the audience here, if you don't know, that's not a defense. So you need to find the right lawyer. Again, Josh Becker on Lawmeto. That's the short answer. But we are indeed trying to put up seminars like this to help you to raise the awareness. Especially in this particular import-export industry, there's so many landmines, as I would call that, because you are already very busy dealing with the logistics nightmare. Like I said, your clients are chasing you, you are chasing your suppliers, and you don't have time to deal with this. You don't have time to flip through the pages to find the customs number for your products. That's where Josh and his colleagues are for here. So with that, I don't see any more questions, and I would like to stay on schedule and still have everybody have a pleasant remaining of the evening, and we will see you again. And we will invite Josh back again for an update on the various updates on the regulatory front. And for that, I thank you, Josh, and I thank everybody else for participating. And this concludes our seminar tonight.